The report is called Double Injustice: Violations of Human Rights in the Investigation of the Ayotzinapa case. And it is a report mainly about torture of the suspects in the case of Ayotzinapa, the disappearance of 43 students from the Ayotzinapa College in 2014. The Office of the High Commissioner has focused on these violations in the process of investigation, and above all in the first stage of that investigation, which were characterized by arbitrary detentions and cases of torture. In fact, we have documented 34 cases of torture where we say we have very strong evidence of torture in the cases of persons who are detained either as supposed members of organized crime or of local police of Iguala and Cocula who were supposed to have been in collusion with organized crime. Now, we are not expressing any views on the innocence or guilt of these persons, but we are documenting in this report the patterns of bad investigation, based on confessions under torture, which happened mainly between October 2014, when the case was taken over by the Attorney General's office, and January 2015. There is one other case from September 2015. And there seems to have been a very clear pattern of such unacceptable methods in the investigation. And what more, when we documented this, we shared the information with the authorities, and in this report we show that there was not an adequate response to these findings, that in 2016 there was an effort to do an internal investigation of the investigation and to see who was responsible for various irregularities, but unfortunately the internal investigator and the then prosecutor general were both dismissed, and the final report of that internal investigation was also watered down. There are a number of violations of human rights, but torture is obviously the main one in this report, and we focus on 34 cases, 33 out of which have medical examinations done by the medical staff of the Attorney General's office. And these document multiple injuries, and these injuries, we have them documented, therefore, in the judicial file itself, and they are explained away in the judicial file in ways which are not credible, that all these people fell or that they had some injuries before from getting into fights. But we also know that a number of them actually were examined at the moment of being detained. These were some of the municipal police, and they had no injuries, and then they arrive sometime later and they have them. Moreover, we have the declarations of these people, the declarations they made before the judge, which describe very clearly and in much detail the way they were tortured, from being asphyxiated by plastic, from being asphyxiated with plastic bags, to getting electric shocks, to being beaten or having threats against their wives and their children. And so we have a rather complete picture here. We also have interviews with these detainees which corroborate what we have from the judicial file, but I would like to emphasize that already the information that we have from the judicial file should have been more than enough for the authorities to thoroughly investigate these allegations, which look very credible indeed. As I said, we have the medical reports which are made by medical staff of the Attorney General's office in the first days. We also have many other pieces of information from the judicial file, including the statements of these detainees before the judge, and we have interviews with these detainees. Surely, the Office of the High Commissioner for Human Rights has a mandate not only for promotion of human rights, but also for protection of human rights. The objective of the publication can be divided in three levels. On one level, it is to contribute partially obviously, to the search for truth and justice in the Ayotzinapa case itself. Another dimension is to contribute to the public debate about the unacceptable character of torture, because there is a general problem in Mexico of the use of torture as a method of investigation. This occurs because the police very often don't have the capacity to use scientific methods, neither do they have the cooperation, the willing cooperation of the citizens, because these citizens don't trust them, so they resort to torture. And this is a general problem. The Special Rapporteur on Torture, Juan Mendez, 3 years ago described this as a generalized issue. We now have a new law, the general law against torture, but it has to be really implemented. And the third dimension, finally, is that of an institutional transformation of the Attorney General's office, which is now called Procuraduría, and it's supposed to be changed into a really independent one called Fiscalía. But it's very important for us that this doesn't end only as a change of names. We really need a different institutional culture and genuine independence of such an office, so that it isn't an office that basically puts political expediency before the real search for truth and justice, as it is now. So we want to stimulate with this report also this profound institutional transformation. We call the report Double Injustice because obviously it is an injustice towards those who were tortured. Whether they are innocent or guilty, obviously nobody should be tortured. This is completely unacceptable, and other violations as well. But it's also an injustice towards the victims, meaning the families of the 43 disappeared students, because we cannot be sure if a narrative constructed under torture is true, and therefore their right to truth and justice is also being compromised. The victims obviously are the 43 students, the 6 other persons who died in the events of September 2014, the families who have been suffering terribly now for 3.5 years. Indeed, there is now a study on the psychosocial effects of this uncertainty for 3.5 years on those families. But we can say that in a certain way also the victims of the bad investigation, of the investigation that uses torture, are victims of the Iguala case, even though they might at the same time be perpetrators, because you simply cannot solve one human rights violation by committing another human rights violation. It is very well known in English. You say 2 wrongs cannot make a right. And in that sense, not just the Mexican people, but the international community itself could see itself as being deprived of truth, because this is a case which has had a lot of international coverage. But once again, I would like to return to the generic issue. There are many other cases of the use of torture as a method of investigation. Last year there was a research published by a government body that interviewed people in prisons, where over half of them said that they had been tortured at one point in their process. So there is a real need to change the institutional culture and to move away from the use of torture, to move away from the use of confessions obtained under torture. For goodness sake, we are in the 21st century. There are 15 recommendations. Some of them are addressed to the Office of the Attorney General, like to really investigate diligently the allegations of torture and establish the responsibilities for those. There are others which are addressed also to the judicial power, for instance, to make sure that evidence obtained under torture is excluded from the process. But there are also some recommendations which are addressed to the Mexican government as a whole, for instance, for this institutional transformation of the current Attorney General's office into one which would be fully professional and fully independent. The conclusions of the report also draw on a number of special procedures, mandate holders of the United Nations who have expressed their concerns about this case, and we can also say the more general concerns expressed, for instance, by Juan Mendez as Special Rapporteur on torture about the use of torture in the Mexican judicial system.